The handwriting expert took the stand at 10:17 on a Wednesday morning, and by 10:49, my uncle's attorney had stopped looking at his client. But let me tell you about my grandfather first. Because this story begins with him and it ends with him and everything in the middle. The lawsuit, the courtroom, the forensic ink analysis, the moment my cousin Damon walked out without looking at me. Everything in the middle is really just the distance between who he was and who his family decided after he was gone, that it was more convenient to believe he hadn't been. My grandfather's name was Ezra James Whitmore. He was born in 1938 in Meridian, Mississippi, the second of 4 children, and he left at 19 with $40 and a Greyhound ticket to Detroit, where he spent 6 years on the line at Ford before moving into skilled trades, then into small-scale property management, then, through a combination of discipline and timing and a quality of attention that I can only describe as strategic patience, into real estate ownership on a scale that surprised everyone who had watched the earlier stages. By the time he was 60, Ezra Whitmore owned 14 properties in the greater Detroit area, 8 residential rentals, 3 mixed-use commercial buildings, a small warehouse he leased to a packaging company, and the house on Calvert Street in northwest Detroit where he had lived since 1971 and where, until he was 83, he still mowed his own lawn on Saturday mornings because he said, "The lawn doesn't care how old I am." He was not a warm man in the conventional sense. He was not a man who said "I love you" freely or who attended school plays or who called on birthdays unprompted. What he was, instead, was present in a way that felt when you were a child like being taken seriously by the universe. When Grandpa Ezra looked at you, you felt accounted for. When he asked you a question, he waited for the actual answer. He asked me when I was 9 years old, sitting at his kitchen table while he read the newspaper and I struggled with long division homework, "Celeste, what do you do when you can't see the path forward?" I said, "I don't know." He said, "You stop moving and you look at what you have. Not what you wish you had. What you actually have." I didn't understand it then. I wrote it down in a notebook when I was 22 when I was going through the worst year of my adult life, and I have thought about it in one form or another almost every day since. My name is Celeste Whitmore. I am 41 years old. I am a licensed estate attorney in the state of Michigan, which is one of the several ironies this story contains and which I will address in its proper sequence. I have practiced family and estate law for 14 years. I am, in other words, a person who has spent her professional life helping families navigate the exact type of dispute that my own family chose to drag into a courtroom against me. My grandfather left me the house on Calvert Street and the warehouse on Livernois Avenue. Together, those 2 properties were appraised at $5.2 million at the time of his death. The house having appreciated dramatically with the neighborhood's revitalization, the warehouse having been expanded and upgraded twice in the previous decade. He left his 8 residential rentals to his surviving son, my uncle Roderick. He left his 3 commercial buildings in equal thirds to Roderick's 2 children, my cousins Damon and Brianna, and to a non-profit vocational training organization he had supported for 12 years. He left nothing to my father, his eldest son, because my father had been dead for 7 years by then, a fact that will become relevant. The will was legitimate. It had been drafted by a probate attorney named Sandra Yee, notarized, witnessed by 2 individuals unrelated to the family, and filed with the Wayne County Probate Court 11 months before my grandfather died. Sandra Yee had known my grandfather for 9 years. She had drafted 3 prior versions of his will, each revision carefully documented, each one reflecting the slow, deliberate redistribution of his assets as his relationships and priorities evolved over the final decade of his life. My uncle filed the lawsuit 4 months after the funeral. To understand why Roderick did what he did, you have to understand what my grandfather's estate represented to him, and what it did not represent to me. Roderick Whitmore is 66 years old. He is the younger of Ezra's 2 sons, the one who stayed in Detroit, the one who managed the properties when my grandfather's health declined, the one who drove him to medical appointments and sat with him during the 2 hospitalizations in his final years. He did those things genuinely. He was not performing. He loved his father, I believe, in a real and uncomplicated way that I respect even now, even after everything. What Roderick also believed, and what no one had ever directly contradicted, was that proximity to care translated into proximity to inheritance. He had spent years expecting that his sustained presence, his practical support, his role as the one who stayed, would be recognized in the final accounting in a way that outweighed the claims of the grandchildren, the nonprofits, the niece whose father had died before the will was finalized. When the will was read and he received the residential rentals, 8 properties, a combined value of approximately $3.1 million, he received them with the face of a man who had expected more and was calculating whether to say so. He said nothing at the reading. He said nothing at the repast. He called me 3 weeks later to ask, in a tone of careful neutrality, whether I had discussed the will with Grandpa before it was finalized. I told him I had not. This was true. My grandfather had not discussed the specifics of his will with me. He had told me once 2 years before he died that he wanted me to have the Calvert Street house because you're the only one who ever understood why I kept it. That was the entirety of the conversation. I had not asked about valuations or percentages or what else the will contained. I don't think Roderick believed me. I think he had already decided before he called that an explanation was needed for why Sandra Yee's will looked the way it did, and the explanation he had chosen was me. The lawsuit alleged that I had exercised undue influence over an elderly man in declining health, that I had gained inappropriate access to his estate planning process, and, the claim that made my hands go cold when I read it, that the will filed in Wayne County Probate Court was not the authentic final will of Ezra James Whitmore, but a document that had been materially altered or partially fabricated, with my grandfather's signature either forged or obtained under conditions that rendered legally invalid. They were accusing me of forging my grandfather's will. I sat in my car in the parking structure of my office building for a long time after Simone called to tell me the complaint had been filed. Simone Achebe, no relation to my previous attorney, a different Simone, was my personal attorney, the one I'd hired for my own estate matters years earlier precisely because I knew as a practitioner that estate attorneys need estate attorneys. She had read the complaint twice before calling me. The forgery allegation is the serious one, she said. The undue influence claim is standard contested will territory. The forgery allegation, if they can support it, is a different category of problem. I asked her how they thought they could support it. She said, they've retained a document examiner. I was quiet for a moment. So, I said, have we? There are things I need to tell you about the 14 months between the complaint and the trial, and some of them are about the legal case and some of them are about what it costs to be accused of something you didn't do by people you grew up beside. Damon was 38 at the time of the lawsuit. We had been close as children. The kind of close that happens when 2 people are near the same age within an extended family and share a grandfather who treats you both like your opinions are worth soliciting. We had drifted as adults in the ordinary way. Different cities, different lives, the maintenance of closeness requiring effort that busy people allow to lapse. But we had never been hostile. We had texted on holidays. We had been at the same table at every family gathering for 30 years. He did not contact me after the lawsuit was filed. Not to explain, not to distance himself, not even to say the obvious. I didn't choose this, he's my father. Nothing. The silence was its own communication and it communicated clearly. Brianna, his sister, was different. She called me 6 weeks in on a Sunday night and said, Celeste, I'm not part of this. I want you to know that. She couldn't testify against her father, she said. She couldn't take sides publicly. But she was not part of it. She said, Grandpa knew what he was doing. He always knew what he was doing. She was crying a little by the end. So was I. I didn't sleep well that year. I ran, which I had done since college, and I ran more than usual. Early mornings before the office, sometimes 6 miles, sometimes more, the kind of running that isn't about fitness but about having somewhere to put the energy that has no other container. My running partner, a colleague named Farai who practiced immigration law 2 floors below me in our building, ran with me on Tuesdays and Thursdays and did not bring up the lawsuit unless I did. When I did, she listened. When I didn't, she talked about other things, her daughter's school play, a case she was navigating, the new Ethiopian restaurant that had opened on Woodward. I am more grateful for those ordinary Tuesday mornings than I know how to measure. At work I was careful. My partners at the firm knew about the lawsuit. It was not something that could be concealed when your own name was in the court filings. They were supportive in the formal, professional way that partners are supportive. They did not reduce my caseload without asking. They did not treat me differently in client meetings. They did not whisper. My managing partner, Henry Calloway, said to me in private, "The allegation is absurd to anyone who knows how you practice." That's not nothing. It wasn't nothing. It helped, in the way that being believed by someone who knows your work helps, even when you know the law doesn't care what your managing partner thinks. My daughter Imani was 11 when the lawsuit was filed. She knew something was wrong in the way that children know things, through the texture of ordinary moments, the quality of your attention at dinner, the way you pause before answering a phone call. She asked me once directly in the car on the way home from her swim practice, "Mom, is the thing with Uncle Roderick serious?" I said, "Yes. But I'm handling it." He thought about this. "Then, did you do what he said?" I said, "No." She nodded. "Okay." She plugged her headphones back in. The complete, uncomplicated trust in that single syllable, "Okay," undid me more than almost anything else that year. I drove the rest of the way home looking straight ahead, not letting her see my face until I'd had 30 seconds in the garage to put it back together. Her father, my ex-husband Kwame, had been cooperative throughout. We had divorced 4 years earlier, civilly with no particular drama, in the way that two people who respect each other can sometimes manage to end a marriage without destroying everything else. He called me when he heard about the lawsuit. He said, "Whatever Imani needs, I've got her." He meant, if this gets worse, if the publicity becomes a problem, if you need to focus, I will cover the parenting. He didn't say it like a concession. He said it like a fact. I wrote that down too. The foundation of our defense was Dr. Richard Holt. Dr. Holt was 63 years old, currently in private practice as a forensic document examiner, previously a senior examiner in the FBI Laboratory Division's Question Documents Unit for 21 years. He had testified in 340 federal and state cases. He had been qualified as an expert witness in 29 states. He had, in his career, been the examiner whose analysis had both convicted and exonerated individuals accused of document fraud, and he was known, Simone had researched him extensively, for testimony that was precise, unembellished, and very difficult to impeach. We retained him 8 months before trial. He spent 4 months on the documents. The family's expert, a man named Theodore Bosch, who had been in private practice for 11 years and had testified primarily in insurance fraud cases, had submitted a report concluding that certain pen pressure patterns and letter formations in the will's signature were inconsistent with the established signature samples from Ezra Whitmore's prior estate documents. Bosch's report was careful in its language. It did not say forged, it said inconsistent with. But Roderick's attorney, a litigator named Carlton Webb, who had clearly decided to lead with drama rather than precision, had decided that inconsistent with and forged were interchangeable in his opening statement. They were not interchangeable. And Dr. Holt's report, submitted to the court 3 weeks before trial, explained in 47 pages exactly why. I won't give you the technical detail of all 47 pages. What matters is this. Dr. Holt had examined not just the contested will but every document in my grandfather's archive, 12 years of signature samples, personal letters, property transfer documents, tax filings, and crucially the 3 prior versions of the will that Sandra Yee had drafted. He had also examined the medical records from my grandfather's 2 hospitalizations, which documented the specific progression of his essential tremor, a condition he had developed in his late 70s that produced characteristic variations in his handwriting that were consistent across all authenticated documents from his final 4 years of life. Bosch had identified those tremor-related variations as evidence of forgery. He had apparently either not accessed or not accounted for the medical records documenting the tremor's progression. Dr. Holt's report demonstrated, with the specificity of a man who had spent 21 years at the FBI, not being wrong about ink and paper. The variations Bosch had flagged were not only consistent with Ezra Whitmore's documented tremor pattern, they were predicted by it. The signature on the contested will matched, with statistical confidence, the authenticated signature samples from the same 12-month period. There was no evidence of forgery. There was overwhelming evidence of an old man's hand, signing his name to his own intentions one last time. Sandra Yee testified about the drafting process. She described the 4 meetings with my grandfather over the 11 months before filing. She described his instructions, his reasoning, his specificity about the Calvert Street house. She described a man who knew exactly what he wanted and said so clearly. She had contemporaneous notes from every meeting. She had them because she took notes from every meeting with every client, because that is how you practice estate law without ending up in court trying to explain what someone meant versus what they said. My uncle's attorney tried to suggest that Yee had been influenced by me, that our professional proximity, we were colleagues in the same area of law, we knew each other, created a conflict of interest. Simone objected. The judge, a woman named Honorable Diane Forsyth who wore reading glasses on a beaded chain and had the manner of someone who had seen this particular play performed many times before, sustained the objection with a brevity that communicated her views on the suggestion without requiring words. Then Dr. Holt took the stand. He was a compact, precise man in a gray suit who spoke the way people speak when they are accustomed to being misunderstood and have decided the best response is extreme clarity. He explained his methodology. He explained the tremor documentation. He explained the comparison between Bosch's analysis and his own, not with contempt but with the measured specificity of a surgeon describing why a previous diagnosis had missed something important. When Carlton Webb cross-examined him, Webb tried 3 approaches. He tried to suggest that Dr. Holt's methodology was subjective. Holt explained in detail why it was not. He tried to suggest that the tremor documentation was incomplete. Holt listed the 11 medical records he had reviewed and offered to walk through each one. Webb declined. He tried finally to suggest that the difference between Holt's conclusions and Bosch's conclusions simply reflected a disagreement between experts. Holt looked at him for a moment. "Mr. Webb," he said, "Mr. Bosch's report does not account for the medical records. If it had, his conclusions would have been different. This is not a matter of interpretive disagreement. It is a matter of whether the relevant data was examined." Webb did not ask a follow-up question. He said, "No further questions." The pen, a nice pen the kind lawyers carry when they want to project confidence, had already left his hand and rolled to the edge of the table. His paralegal quietly stopped it before it fell. I looked at my uncle during Holt's testimony. Roderick sat at the plaintiff's table with his hands folded in front of him, and I watched something happen on his face that I recognized from my own professional experience. The moment when a client understands that the story they believed, the story they paid someone to tell in public, was not the story the evidence supported. It is not a dramatic moment. It is a quiet one. Looks like a person becoming very still. He had not, I think, manufactured the accusation from nothing. He had believed it on some level, had needed to believe it because the alternative was that his father had looked at the full accounting of his life and his relationships and had made a clear-eyed choice to give the house and the warehouse to the granddaughter whose father was dead, whose connection to the old man on Calvert Street was something Roderick had never quite been able to categorize or compete with. That was harder to live with than a conspiracy. Conspiracies have villains. What Grandpa Ezra had done was simply exercise his own judgment quietly the way he exercised everything. I understood why that was unbearable. I did not forgive what Roderick had done with that unbearable feeling. But I understood it, and understanding it was its own kind of loss, because it meant I couldn't even hold clean anger about it. It was grief dressed up as litigation, and grief, whatever form it takes, is still grief. Judge Forsyth ruled from the bench at the close of testimony, which Simone had told me was unusual and which she said, when it happened, was a good sign. The judge found that the will of Ezra James Whitmore filed with the Wayne County Probate Court was authentic, properly executed, and legally valid. She found that the allegation of forgery was not supported by competent evidence and was, in fact, directly contradicted by the forensic analysis presented by the defense. She found no basis for the undue influence claim. She also said, and this is the part one wrote down verbatim on the legal pad in front of me, that the court notes with concern that a forgery allegation of this nature, made against an estate attorney with no prior disciplinary history, constitutes a serious professional harm and was advanced without the evidentiary foundation that such a claim demands. She awarded sanctions. Roderick and his attorneys were ordered to pay $61,000 in defense costs. My uncle did not look at me when the ruling was delivered. He stood when his attorney stood, and he walked out of the courtroom with the deliberate posture of a man who has decided not to give anything away, and I watched him go and felt nothing that I could cleanly name. Damon was in the gallery. He had attended every day of the trial, sitting in the second row behind his father, not testifying, not participating, just present. When the ruling came down, he stood. He looked at me for the first time in 14 months. It was a long look. Not an apology, not an accusation, just a look that contained several things he had apparently decided not to say. Then he walked out behind his father, and I did not see him again that day. Brianna texted me at 4:17 that afternoon. It said, "I'm so glad." That was all. I texted back, "Thank you for calling me that Sunday." She replied with a single heart. We have not spoken since, but the two messages sit in my phone like a small, careful record of what survived. Sandra Yee and I had dinner 2 weeks after the ruling, at a Thai place on Cass Avenue that we'd both been meaning to try for a year. She ordered the same thing I ordered without consulting the menu, which told me we'd been in the same circles long enough to have absorbed each other's taste without noticing. We talked about the case for a while and then we talked about other things. Her upcoming retirement, my daughter's swim meet the following weekend, a probate case I was navigating that had its own particular family complications. At the end of the evening she said, "He knew you'd fight for it." I looked at her. "Your grandfather," she said. "In one of our meetings, the third one I think, he told me he was leaving the house to you because you were the only one who would fight for what was right even when it cost you something. He said he'd watched you do it since you were 9. I didn't say anything for a moment. "He never told me that," I said. "No," Sandra said. "But he told me. The house on Calvert Street is mine now. I have not moved into it. I have a home in Ferndale where Imani goes to school and where her life is rooted, and uprooting that for a symbolically significant property does not serve her and would not have served my grandfather's intentions, which were never about sentimentality but about stewardship. I have done significant repairs. I have refinished the floors that needed refinishing. I kept the kitchen exactly as it was, including the table where I sat with my long division homework in 1991. I have started the process of registering the property as a historic site, which is a long and bureaucratic process in which my grandfather would have found both appropriate and slightly absurd. I mowed that lawn for 50 years, now they want to put a plaque on it, and which I am pursuing anyway because stewardship means something. The warehouse on Livernois is leased to a manufacturing company that makes components for electric vehicles. The lease generates reliable quarterly income that I have directed, in part, toward a college fund for Imani and, in part, toward the vocational training nonprofit that my grandfather named in his will. I did not have to do the second part. I did it because he had done it first and because I understood finally what he had seen in that organization. Young people learning skilled trades the way he had learned them, building the foundations of something from the ground up, the way he had built everything. My grandfather knew what he was doing. He always knew what he was doing. What I lost in winning is harder to describe than what I kept. I lost a version of my family that I had been without fully acknowledging it, still hoping might become something different. Families that are not close maintain a kind of potential. The possibility that some future gathering, some shared crisis, some accumulation of years will soften the distances and make the warmth available that was always theoretically there. The lawsuit closed that possibility in a way that couldn't be reopened. What was left wasn't hostility exactly. It was a finalized distance, an acknowledged separation. A situation where everyone understood the accounting. I understand the accounting. That is my professional skill and my personal inheritance. I know what documents mean, I know what intentions look like when they're properly recorded, I know the difference between what families say they want and what they actually do with what they're given. My grandfather gave me the house he'd kept for 50 years and the warehouse that had been the engine of his final decade. He gave them to me not because I was the closest or the most present or the loudest claimant, but because he had watched me since I was 9 years old, stopping when I couldn't see the path forward and looking at what I actually had. I did that for 14 months while my uncle's attorney called me a forger in a courtroom in Wayne County. I am doing it still on a Tuesday morning in November, running 6 miles on a route that passes 3 blocks from the house on Calvert Street because I chose this route for a reason I didn't fully examine until recently. I run past it. I don't stop. I note it the way you note something that belongs to you and doesn't require proving. The lawn still needs mowing. I hired someone, a retired gentleman named Earl who does 4 houses on the block and who, the first time I met him, told me he'd known my grandfather by sight for 20 years and that man kept the best lawn on the street. I told him my grandfather would have considered that a reasonable legacy. Earl laughed. He said, "You must be the granddaughter he talked about." I said, "Which one?" He said, "The one who was going to be a lawyer." He said it like it had already been decided years ago before I knew it myself. Like my grandfather had known what he was looking at and said so casually to a neighbor on a Saturday morning while the grass was still wet, the way you state facts that don't require argument. I ran the rest of the route and went home and made breakfast for Imani, who had a swim meet at 9, and drove her there and sat in the bleachers with the other parents and watched her cut through the water with the clean efficiency of someone who has learned that you don't fight the resistance. You move through it with enough precision that it barely notices you. She came in second in the butterfly. She climbed out of the pool and found my face in the bleachers immediately, the way she always does. I gave her what I had. 2 hands raised, a real smile, everything.